Welcome to the panel, Investment Law and the Future of International Energy Governance. I'm David Atanasio. I'm an associate in Deckard LLP's International Arbitration Group and a member of the ILA American Branch Board of Directors. I'm honored to be chairing a panel of leading academics and practitioners that will consider a pivotal issue: how international law should govern energy investment. Energy has been one of the driving forces behind the development of international investment law, even before investment treaties and the ICSID Convention reshaped the field. It remains relevant today. Last February, a cold front caused major disruption to gas markets in both Texas and northern Mexico and left many without power and in a state of deep freeze. We're now experiencing sky-high gas prices amidst a global supply chain crunch. And climate change is driving regulatory and corporate governance shifts in an effort to limit global temperature rises. This panel will consider how investment law can and should respond to these and other events in the way it regulates energy investment. I'd like to now introduce the panelists. First, we have Guillermo Garcia Sanchez, who is an associate professor at Texas A&M Law, and he is a former associate at Curtis Malay's International Arbitration Team and was also a legal advisor in Mexico's Ministry of Foreign Affairs. Next, we have Kathleen Clausen, who is an associate professor at the University of Miami School of Law and non-resident senior fellow at the Georgetown Institute of International Economic Law. Professor Clausen is also the former Associate General Counsel at the Office of the U.S. Trade Representative. Diora Zieva is counsel at Denton's in New York City, and she is also an adjunct professor of law at Cornell Law School and at the Fordham University School of Law. And finally, Tim Meyer is professor of law and director of international legal studies at Vanderbilt Law School. He is a former attorney advisor at the U.S. State Department. And with that introduction, I turn over the floor to Guillermo Garcia Sanchez to kick off the panel.
Thank you so much, David, and thank you so much, Kathleen, team, Diora, for being here today. And thank you so much to the association for organizing this panel, which, as David mentioned, I think we're in a pivotal moment where energy governance and the future of the investment regime are colliding again. Even though, as David mentioned, this is an area that has always been an important area of practice and litigation. Even if you think about it, in the last 10 years, investment cases registered at the ICSID, by ICSID, there's always between 30 and 40% of the caseload involving energy. It can be either power generation, dams, or oil and gas, but always energy has been a big part of investment law. And if you think about it, even before, energy, that the biggest cases of investment arbitration started with oil and gas deals in Libya, right? We all remember the Libya, the Liamco cases. Even the U.S. Iran Claims Tribunal had a big number of those cases have to do with the oil and gas industry. So energy litigation in investment and investment law have always been hand in hand. So to start the panel, I wanted to at least share my views on where I think the new challenges are going to be coming up and how they interconnect, particularly in our region, the USMCA region. So one of the areas that I see rising particularly is basically the concept, what I would say, energy nationalism. And this can have different versions. So this can be either hoarding energy resources in the face of skyrocketing prices, but it also can be energy nationalism in the sense of the resurgence of state-owned companies and monopolies over certain resources to develop resources nationally. We see that concretely, for example, happening in Mexico. But also energy nationalism can arise from policies connected to climate change. So we see that, for example, in the United States. Right now, there are some states that are preventing certain resources from leaving the United States under the umbrella of combating climate change, so denying permits for the construction of pipelines that could actually, in theory, help the grid expand and make production of energy more efficient in the United States. So energy nationalism can have different versions. So that also comes in hand with, as we all know, right now we're in current redefining certain concepts on investment arbitration. And one of them obviously is the legitimate expectations of the investors, right? So when the investors made many of the investments that are currently that are taking place around the globe, climate change wasn't as an important topic as it is today. But after the Spanish saga and the Italian saga and the Czech Republic saga, we see now that also renewable investments are facing challenges, especially when states give an enormous amount of leeway in terms of tax incentives or regulatory incentives so that they come and invest. The big questions arise whether once those investments are in place, whether the state can withdraw those incentives, even though they might be for a good reason. So, at least the consensus is that right now, legitimate expectation is something that is being discussed. There is a consensus that state has the right to regulate, at least in the health and environmental laws area. But, how are these things going to be put in place, especially if now states start to change certain contracts or change certain concessions in order to address certain climate change issues? So, for example, I at least identified 4 possible areas of litigation in this realm. So I would see that we can perceive in the future that SOEs and certain governments are going to renegotiate with existing oil and gas and fossil fuels-based companies as they try to comply with their commitments with the Paris Climate Change Agreement or other environmental-related agreements, especially power generation companies that are based in either coal or diesel. They're going to face a lot of new regulations and new pressures from governments to renegotiate those contracts. Thirdly, I see also there's going to be an important discussion about balancing again the budgets, especially after COVID-19, whether the governments can withdraw some of the tax incentives that were given a couple of years ago for renewables, and what are the consequences for that for the investments, whether that would breach the legitimate expectations of the investors, and in some cases, the reasonable rate of return that had been negotiated originally. And finally, and your team will give us a little bit more of an insight, the rise of the carbon tax adjustments that are out there, right? There's a big push of generating new carbon tax adjustments, and that might impact some of the investments done in certain regions under certain conditions. So how are arbitration panels going to decide these cases? That is at least up in the air, where the arbitration panels are going to take into consideration more of the public interest and the rationale behind these decisions, where that's going to be different from the original cases that we saw at the start of the 2000s, right? The Venezuela, the Bolivia cases, the Ecuador cases, where tribunals were a little bit less willing to give some leeway to the states to regulate those sectors and change the rules of the game. Whether now the climate change goals, whether those are going to help investors to reach investment tribunals to reach different conclusions than the ones in the early 2000s. Concretely now, when it comes to the USMCA, I think we use the USMCA as an example of how these things might play out. One of the challenges is that even though the USMCA was being renegotiated during the time where we were aware of climate change and all these challenges, I think Mexico, United States, and Canada did a poor job in trying to address these challenges consistently. So, for example, we have the famous Chapter 8. We don't even have an energy chapter, which in and of itself, I think it's surprising, right? Considering that if there is one region in the world that is energy integrated on the 3 countries is the North American region. So we don't have an energy chapter. We used to have one in NAFTA 1994. Now we don't have even one on the USMCA. We have the side letters between the United States and Canada, but again, there are big questions whether their actual commitments can be enforceable. And we have a Chapter 8 that was negotiated to please the Mexican government, especially the current administration, that shows that vision of energy nationalism, right? Recognizing Mexico's right to develop its hydrocarbon resources the way its constitution mandates it for the benefit of the country. But at the same time, we have carve-out exceptions in investment in the ISDS mechanism, particularly for those kind of contracts, right? So, there are mixed messages in the treaty that we don't really know how they're going to play out. I think ultimately another challenge of the investment regime is that many of these energy-related cases, when we look at the case law, there are always the outliers in terms of amount of damages awarded and the time that it takes to resolve this dispute. So average investment cases under ICSID take between 4 and 5 years. But when it comes to energy, we bump that all the way to 7, 10 years. And then we don't even talking about how, additional steps to enforce the award, which sometimes they are not registered at the ICSI website, and those usually might even take 1 or 2 more extra years, depending on the jurisdiction. And in addition, you can add a couple of months for the actual money to be distributed back to the investor. So we're talking about 15 years generally for these big energy-related cases. And that generates incentives for the governments to say, well, I can enact new policies now, but who knows who's going to pay in 15 years, right? It might be another government. And when you have, especially in governments where democratic processes are in transition, there's a very short sight for these kind of decisions. There's not really a sense of the state is going to be liable. It's probably they're thinking another administration down in 15 years, so we might as well take advantage of renegotiating the contracts now. So with that, I hope I set up some of the important aspects that I think are happening and the challenges that are happening. And I leave the microphone back to David to coordinate the conversation.
Okay, thank you, Guillermo, for that excellent introduction to the set of issues that we're grappling with today. I think with that, I will ask Kathleen to provide her observations.
Great. Thanks so much, David. And thanks also to Guillermo for bringing us all together so expertly. It's wonderful to be a part of this panel. I've already learned a lot from Guillermo's short remarks and look forward to hearing from my co-panelists. But in a way, I'd like to sort of circle around to the other side of what Guillermo has expertly described, and that is look at the intersection between investment on energy issues and trade trends that we're seeing, and sort of broadly defined on all of these terms. So rather than look at the substance and what we might expect to see from individual panels, I want to talk more about what he described sort of more toward the end of his remarks about the institutions. And so my approach is really through this back door. That is, when I'm thinking about these issues, I'm often doing it through somewhat of a comparative lens, if you will. That is, pardon me. How we should compare what's happening in international economic law across investment, trade, and other areas, and how those trends might intersect with each other. So two sort of hot topics, pardon the climate change pun, in international economic conversation, at least when we talk about products, I think are cars and solar cells. And I raise these, as you'll see, I think they are highly motivating for different disputes and conversations we're having in both parts of international economic law. So the latter, the solar cells, of course, directly connected to energy governance, and the former slightly less directly, but still very much top of mind. So on the trade side of the shop, those goods, both the solar cells and the cars, continue to motivate considerable developments, normative development and additional conversations, and disputes at the same time. They're simultaneously the source of great cooperation and consternation at multiple levels, right? State to state level and among multiple types of players. So when we think about our shared energy framework, I think that the politics around those two in particular, and we could maybe add wind and certainly some of our other more traditional energy spaces, but I think those are the most salient driving factors, again, sorry, the car pun, to how we shape our free trade agreements and what we think about also as trade remedy strategies. And those in turn will have an impact on how we think about investment law, what that should be, what it should include, who should be at the table as a substantive matter, as well as procedurally, and thinking about the tools that we use. And I raise this because when seen in this light, the debate about whether there should be investor-state dispute settlement to deal with energy issues in US trade agreements at least, and particularly within the Republican Party in the last administration, that comes across somewhat as an afterthought, right, when we're talking about IEL instruments and energy. Yes, there's a strong lobby that got us to the outcome that Guillermo described, but the rubber hitting the road was really in these other parts of the agreement. So the United States came into USMCA, the negotiations generally on NAFTA, with cars on the brain. Right? We saw that in the conversation that came around on labor, that came around on rules of origin, on supply chain issues. So it was cars were very much the motivating factor to get us into a renegotiation at all. Climate change, environmental issues, and those that come with energy more generally were not front and center. And as Guillermo said, that you see what we got. They were at the very best secondary. But now I think those issues are colliding more directly. And in addition to the ways that you've already heard from Guillermo, there are headlines in the news this week about the infrastructure bill, electric vehicle tax credit plan that both Mexico and Canada have questioned as being harmful to their industries, but more importantly for our purposes, consistent or inconsistent with USMCA. Likewise, the Mexican power bill, which I'm sure we can say more about, that may or may not cancel renewable energy contracts. And so again, these intersections between what's happening in the trade space and what's happening in the investment space, I think can't be ignored. So all of that conversation brings us to think about how these things resonate across both of those subfields. Where I think they diverge more obviously, or even maybe more importantly, is with respect to the options for remedies, for targets and tools. Remedies, targets, and tools. So let me talk about each of those from the sense of sort of the approach we take to this area of governance. We could have this conversation looking at strictly at national policies, such as the ones I just mentioned that are now under debate. And we could ask what ought to be allowed, what can be challenged, either using trade or using investment, using those rules that we have. That approach, I'll call that approach A. That's very state-centric. Even if we let investors challenge state action when it comes to energy governance issues, the focus is on the state and what the state is doing, those national policies. So approach A for both trade and investment is looking at what states are doing and allowing different other actors to challenge those state actions. We could alternatively consider how our present government structure provides carrots and sticks directly for companies. In that approach, call it approach B, we think of companies as the most important actors in the space rather than states. This is a firm-centric policy. It thinks of the corporations as actors both with responsibilities as well as with privileges under our IEL commitments, under IEL instruments. And a third approach might outsource these issues, outsource them to some sort of third party, a secretariat, a shadow unit, something that would take on these questions and issues so that states don't have to. And we'll call that approach C. Approach C is more cooperative amongst states, and non-states maybe involves more soft law than the other two would. Now, of course, none of these sort of perfect models, ideal models, are mutually exclusive. We could imagine hybrid versions of each and their intersections. But what I want to highlight is that in trade, particularly on environmental issues as well as on labor, we're seeing a move toward approach B. Approach B, the firm-centric one. This approach that spends less time on normative development, more time on institutions. Not capacity building, but institution building, moving from rules to tools. And this has meant change targets for compliance and enforcement as well. I think there's potential to see that approach that we're seeing in trade extended even farther and doing somewhat what would flip the investment regime on its head. It would allow greater extraterritorial reach for governments to work with companies that are not complying with energy or climate change goals, for example, once those goals are set and agreed, or related ones are set and agreed. Saying that, and maybe to some of you who are investment experts, that maybe it sounds like kryptonite, right? This sounds like something, how can you possibly say that in investment conversations? And even very recently, I think that would be how it would be received. But today it's a reality in other parts of these agreements that are juxtaposed right next to investment chapters, even if watered down as we have in USMCA. So this approach, what I think could come to pass and have greater traction in the future, would make companies more the target as well as the police on these issues. Now we can query separately whether that's desirable, but I don't think it's far out of reach. And let me just give one example of what's happening in trade, and then I'll turn the floor back over. So we could take the Peru-US Trade Promotion Agreement, where under that agreement, the United States can take action directly against Peruvian companies that are engaged in illegal logging. So the United States can actually stop shipments of timber from entering the United States, right, if the companies are not complying with the rules that are now part of Peruvian law. This is found in the Peru-US Trade Promotion Authority Forest Annex, and it remains the first of its kind, although some of the aspects of the USMCA labor institutions resemble its features. If you look in the Peru trade agreement, you see an illustrative list of actions that the United States can take with respect to the shipment of goods, of this timber, or the enterprise that is responsible for the illegal logging. And it can deny entry to certain products for up to 3 years, or until there's a separate committee can determine that the company is now complying with all the applicable laws and regulations and so forth. But this company-specific annex has already been tested a couple of times. It was tested first in October 2017, when the Trump administration denied entry of timber products and exports by a Peruvian company. Then again in July 2019, when the US Trade Representative directed the US Customs and Border Protection to block future timber imports from a different Peruvian exporter, given that it was illegally harvesting timber farther down the supply chain. So at the time that the Trump administration said that this move was a way to ensure that US trading partners live up to their obligations by not allowing illegally harvested timber to be exported to the United States. And then query whether the focus there really, when you say US trading partners, is the government of Peru, which has sort of said we've done all we can, or whether it's the companies involved, which I think it's certainly more the latter. Now, of course, there are questions of visibility in applying these different tools. There's questions of fairness and selections made under these different tools. So I think those are all issues that policymakers will need to pay close attention to as this tool I just described and others like it move forward. But I just would only sort of put out to this group that I think there remain multiple options on the table beyond a sort of business as usual approach to our investment institutions. And those may come to pass more readily in the energy space than we see in perhaps other areas of our international economic governance. Back to you, David. Thanks.
Thanks, Kathleen. Now I'll turn it over to Diora to provide more of a practice-based perspective on energy governance.
Thank you very much, David. I would like to take this opportunity to thank the American branch of International Law Association for the invitation to contribute to the International Law Weekend, to Guillermo for putting together this panel, and to my co-panelists for making this all happen. It is really great to be here. As discussed by my colleagues, there is an increased global concern over climate change that has affected disputes in the energy sector. So today, I'd like to provide an overview of the trends in energy disputes with a focus on disputes in the renewable energy sector since the early 2000s, and then to discuss the challenges of this sector for the states and investors, and then address the most relevant case law on this issue so that we can look at the global trends and disputes in the sector. And I would welcome your thoughts on this topic. So first, I think it is important to explain how the renewable energy sector presents a unique set of challenges for states and investors. So with the increased global focus on climate change in recent years, there has been an increase in both a number of states making pledges towards meeting climate goals and urgency with which this state and international organization approach these goals. So for example, internationally, the International Energy Agency has issued the Net Zero by 2050 report, prescribing the elimination of fossil fuels in its roadmap for the global energy sector. In the US, we have seen the ongoing fight over the infrastructure bill, which progressive politicians want to be conditioned on the climate change and social protection measures. And given the targets set in the Paris Agreement and the United Nations Sustainable Development Goals, we can expect that the states will continue to focus on the renewable energy sector as part of their efforts to meet these goals. So from the state's perspective, the renewable energy was and continues to be an area with abundant opportunity for growth for the local renewable energy industries. So for states with economies that are highly dependent on the fossil fuels, it also provides an opportunity for diversification and entry into growing markets. From the investor's perspective, the sector similarly presents opportunity for growth and investment. However, it is ripe with risks such as changing regulatory framework and potentially low level of returns of investments. So the renewable energy sector exists at this intersection of open competing interests. On the one hand, like other sources of energies, it is highly regulated industry and the domestic level. On the other hand, increasing investment in renewable energy is key to a state's ability to achieve this climate change goals. So these compelling concerns have played out in various arbitrations over years, starting with so-called, as Guillermo mentioned, Spanish saga and the renewable energy arbitrations against Italy and Czech Republic. So by way of background, in early 2000s, Spain adopted a set of incentives guaranteeing a high level of profitability for producer of energy derived from renewable resources. And there was a set of measures that intended to attract foreign investors, and that included a so-called special regime that granted producers certain rights and privileges, in particular, fixed fee on tariffs that guaranteed reasonable profitability rates to investors. And Italy and Czech Republic adopted similar measures. But following the 2008 financial crisis, Spain, Italy, and the Czech Republic became sort of rolling back some of these measures to help with the growing tariff deficit. And in particular, Spain enacted regulations that limited investors' profit, and in 2013 abolished the fixed fees in a tariff system. So the result was that as of September 2021, Spain now faces its 50th investment claim over these renewable energy reforms. So there are several lessons to be drawn from these cases. One, I think it is important to distinguish between the types of measures that were found to constitute a breach and those that were not. So some commentators divide tribunal's decision into sort of two mainstream lines of reasoning concerning what constitute legitimate expectations for an investor. The first was set in one of the first published decision, Schrein versus Spain, where tribunal examined that this pre-2013 measures instituted by Spain and found that a scaling back of this regime was not a breach of APT, fair and equitable treatment. So the tribunal said that there was no explicit commitment by Spain not to modify special regimes, so that the tribunal found that the investors should have contemplated the changes and adjusted their expectation accordingly. In the second line of reasoning, it's exemplified in ISDS versus Spain or Nova Energia versus Spain, where both tribunal focused on the post-2013 measures, finding that regulatory regimes cannot be changed in ways that hurt the value of the investor's investment. Another lesson is that there continues to be much ambiguity concerning where one draws the line between the state's ability to regulate its energy sector and what constitutes an investor's legitimate expectation. So for example, in ISDS, the tribunal recognized that Spain was facing economic difficulties and had to implement measures to address its tariff deficit. However, it also found that the regulatory measures it chose were not reasonable, quote unquote, although the tribunal did not identify what reasonable measure would be. And this ambiguity is perhaps indicative of the tribunal's general concern about the need to strike that balance between investors' desire for a fair and consistent framework and host states' mandate to implement regulatory changes. So interestingly, although commentators have warned about this regulatory chill, quote unquote, that could result from tribunals' decisions to side with investors, that has not been the case. A recent analysis of the Energy Charter Treaty cases demonstrate that where renewable energy investors have been successful, this was not because the climate-friendly projects were given special treatment or deemed so important that their operations outweighed a state right to regulate. So last, I'd like to spend a few minutes to examine how these issues I just discussed are likely to continue to surface in energy disputes. In general, the number of disputes related to renewable energy continues to grow. So, for example, as of August 2029, out of total of around over 140 cases filed under the Energy Charter Treaty, over 60% concerned renewable energy. In the last decades, countries in different regions of the world began implementing climate goals set out in those global or regional instruments that we discussed. And a great examples are members of the states of the European Union. And since the early 2000s, the European Union encouraged member states to incentivize the renewable energy sector. For example, in 2008, Romania passed a law that introduced a support scheme to promote electricity from renewable resources. And as a result, in 2013, Romania installed more than 1 gigawatt of photovoltaic parks, which placed the country in the same category as a global players like UK or Italy. But however, later on, in 5 years later, I believe, Romania began changing prices of renewable in energy, introduced quotas, postponed the period when solar investors could trade certificates at centralized trading markets. And following these changes, dozens of investors initiated arbitration against Romania. I believe in the last 4 years, 44 solar investors from Europe and Middle East filed exit claims, alleging that Romania's renewable energy system breached the Energy Charter Treaty. Separately, another trend we see is that Spain is taking preventative measures to avoid further disputes. It is offering foreign investors economic incentives that can only be accessed if they drop their investment cases. Another important example is found in states that have enacted legislation to meet their climate goals. Here we're seeing claims from investors in fossil fuels. The Dutch government decided in 2018 to shut down all coal-fired power stations by 2030. And as we know, German utility RWE filed a suit under the ECT, Energy Charter Treaty, alleging that Netherlands failed to allow adequate time and resources to transition away from coal, claiming that investors had legitimate expectations to rely on prior Dutch policy regulating fossil fuels. And although the state's defenses has not been made public, it appears that the Netherlands is going to focus on the state autonomy and its inherent right to regulate. On the other hand, some companies have agreed to abide by the changes in Netherlands law. For example, it's been reported that a Swedish company mentioned that it will not object to the closure of coal-based plants, provided that the government funded the plant's dismantling and compensated the workforce. So it can be expected that the states formulate their commitments to combating climate change, but there will be a push for changes in investment treaties to grant state more leeway. There has been stark opposition from activists and politicians as a result of claims. And states are also drafting new bilateral investment treaties that would reflect their new commitments. And those newer bilateral investment treaties, such as the new draft model BAT in the Netherlands case, is likely to now expressly reference the state's right to regulate environment. Really quickly, in Latin America, there has also been a movement by most states to incentivize investments in renewable energy sector as part of meeting climate goals. So for example, Peru, Uruguay, Ecuador, and Panama have implemented feed-in tariff schemes to incentivize renewable energy products. While, for example, Argentina, Colombia, Costa Rica, Mexico, and Guatemala have implemented tax incentive systems. So it is highly probable that the issue of states' autonomy to regulate its energy sector will continue to collide with the investors' legitimate expectations under the treaties and agreement over the stability of the environment. So as the states move forward with the commitments to environmental protection, I think we would all agree that it remains to be seen how their regulatory regime develop and how investors will adapt this changing circumstances. Thank you.
Thank you, Diora. That was extremely interesting comments on the current state of affairs in the field. Next, we'll pass it over to Tim to talk about issues including carbon border adjustments.
Great. Well, thank you, David, and thank you to Guillermo again for organizing, and to Kathleen and Diora for great conversations. So I want to talk a little bit about carbon border adjustments and related domestic carbon regulation, carbon pricing policies, but more generally carbon regulation as they're tied to carbon border adjustments. And I think in some ways this is maybe a nice place to end the sort of this portion of the panel. We've obviously got a lot of different climate-related measures that governments are trying out as they think about how to combat climate change and meet their Paris commitments. And one of the really big ones has been carbon border adjustments. Now, carbon border adjustments are actually a trade policy, but I want to suggest that they have implications both for investment as well as potentially for investment law. So I think first it might be useful just to explain a little bit about what a carbon border adjustment is and where they're coming from. So essentially a carbon border adjustment is a fee of some kind, usually something like a tax that is assessed on products that are being imported from a foreign country that ostensibly has a lower carbon price than the market into which the goods are being imported. And the basic idea is just to level the price of carbon that a product in a given market faces. And so the leader in this space has been the European Union. I think as many of you will surely be aware, the European Union has rolled out its proposal for a carbon border adjustment earlier this summer. And the way the carbon border adjustment in the EU works, which is in general terms the way these things are supposed to work, is that there is a domestic carbon price that applies to covered sectors of the European economy. These are primarily energy intensive sectors, things like steel, cement, chemicals. They are subject to pricing under the EU's emissions trading scheme. And they therefore face a potential disadvantage insofar as imports of the same products from overseas, from countries where there is not a carbon price, are going to be cheaper to produce and therefore will be cheaper in the European market. There's a competitiveness concern from a trade law point of view. Now, the European Union is going to fix that by imposing essentially fees on imports that are going to be tied to the domestic carbon price that comes out of the emissions trading scheme. So that's the way a carbon border adjustment is in sort of general terms meant to work. It's meant to essentially attach essentially a tariff on imports that would match with whatever the domestic carbon price is. The EU, although it's the leader, is far from the only country that's looking at this. President Biden has talked about this. He talked about it as a candidate. The administration has continued to talk about it. The UK is talking about it as they have separated out. They've implemented an emissions trading scheme domestically as part of their Brexit that basically replicates the EU system that they left behind. And they're looking at a carbon border adjustment system. Canada is talking about this, Japan. So carbon border adjustments appear to be coming to a wide range of countries. Now, it's a little odd maybe at an investment panel to talk about what is a trade measure. So let me suggest two ways in which carbon border adjustments are linked to investment. The first is that carbon border adjustments are primarily about solving an investment problem. The way we usually describe the problem that carbon border adjustments are designed to solve is carbon leakage. That if you have a high ambition or costly domestic carbon regulation, what will happen is producers will shift overseas to countries where essentially, although we don't normally describe it this way, energy is cheaper. And because energy is cheaper, they'll have lower production costs and therefore have a competitive advantage when they import the products back into the market that has high ambition domestic carbon regulation. So in the trade space, we don't normally describe this as an investment problem, but it is. What you're basically saying is that your domestic carbon regime causes an outflow of investment into foreign countries that results in a variety of things that politicians don't like fewer jobs, fewer manufacturing jobs, and potentially even just the investment itself in terms of outflow. Carbon border adjustments are basically a trade tool, I'd like to suggest, that are designed to solve an investment problem that arises from domestic, high ambition, domestic carbon measures. The second thing I want to say about carbon border adjustments as they're related to investment is that you might think that, given the general description, that they really shouldn't be a problem for investment law. They're designed to shift investment patterns, but they may not really be the kind of thing that's going to give rise to investment claims. I think there's something to that. They really are trade measures that are likely, I think, to face both diplomatic and potentially legal challenges as trade measures. But I do think there's the potential for them to be a problem for the investment law system as well. And so let me tell you why. So the way we normally think about carbon border adjustments is that they are designed, as I've described, to basically be a way to protect the competitiveness of a domestic industry that is likely to face pressure from cheaper imports. And the whole idea behind a carbon border adjustment is that it is simply supposed to mirror the domestic price and apply it to imports. In practice, though, that's not actually really how it works. Because what happens when you phase in a carbon border adjustment is that you have to start adjusting your domestic system if you hope to have a plausible claim that your domestic system and your carbon border adjustment system match up. There are a couple different reasons for this. One, which Guillermo has mentioned, is just the rise of nationalism. So there's a lot of attraction to using a carbon border adjustment as a means of potentially protecting certain kinds of domestic industries and giving them some sort of advantage. So it may be that your carbon border adjustment actually gets out ahead of your domestic carbon pricing system. And then you need to, if you're going to try to comply with trade rules, you need to actually increase your domestic carbon regime, your carbon ambitions in some ways. And it may also be the case that you had existing measures in place in terms of incentives or allowances that industries, which would include foreign investors potentially, that were operating in your country benefited from, that are likely to be removed. And so there's a couple of examples of this. So the first is that the European Union is going to remove allowances under its emissions trading scheme that it's had in place. The allowances were the primary vehicle through which the EU addressed these competitiveness concerns that arise from its domestic emissions trading scheme. It's going to replace those with a CBAM. In order for the CBAM, that is a carbon border adjustment mechanism, in order for it to be effective, you have to actually make sure that your domestic price is high enough for your carbon border adjustment to actually matter for imports, which involves withdrawing the allowances. Canada, in its sort of initial consideration of whether or not to impose a CBAM, has considered similar kinds of issues. It has similar sorts of incentives, subsidies for companies that operate in Canada. And it's looking at, if it imposes a CBAM, it has to withdraw those kinds of incentives. And for reasons that Guillermo and Diora have mentioned, right, the withdrawal of those incentives can, in some circumstances, if it's done too quickly, if it's done in a way that runs contrary to the expectations of an investor, actually could end up giving rise to investment claims under some of these kinds of treaties. So the result, and I think I'll end here so we have time for conversation. The result is that this measure that, I think we've been talking about it a lot in the trade space over the course of the last 6 months or a year. I think we haven't yet thought through the way it's likely to ripple through the larger international economic space. And as the sort of spread of these kinds of border measures both shift investment patterns, but also shift the way states think about their domestic regulation of energy intensive industries and energy resources. You could imagine governments, I think, very easily start withdrawing these kinds of incentives that they have put in place in order to marry up their border system and their domestic carbon system in a way that actually has an adverse impact on foreign investors. And thus leads to claims, depending on where you are, potentially under the ECT, under BITs, and so forth. And so I'll stop there and turn it back to you, David.
Thanks, Tim, and thanks to all the panelists for excellent comments and really providing a good overview of where we are with the major issues. I wanted to turn now to questions, and while I have a series of questions for the panelists, I also encourage anyone in the audience that has a question to put it in the chat box, and I'll try to get to those. I see we already had one come in. But I'd like to start with just a big picture question about the current international investment regime. Some of our comments have been on possibilities of reform or alternatives to what we currently have. But for the time being, we are stuck with a series of some 2,600 BITs that are currently in force, or including trade provisions and trade treaties. So, first question is, when is the international investment regime likely to hinder a renewable energy transition, and when is it more likely to provide discipline for that transition? I turn it over.
Can I jump in here?
Please.
And here, I think if I could start the conversation, I would love to hear from my co-panelists their thoughts on the issue. But I think you're raising a very important point because there are several things to consider. When it comes to hindering a transition, a couple of things come to mind. For example, as I discussed, as illustrated by the RWE versus Netherlands case, investors in fossil fuels may continue initiating claims against states that attempt to bring their energy sectors in line with the climate pledge. Or like another example, that a current international investment regime often leaves states having to foot enormous bills to satisfy their words. So for states with already strained budgets, the allocation of resources to compensate investors may mean a decrease in spending on other initiatives, including those intended to help with the renewable energies transition. Another issue is the availability of lost profits in treaty arbitration. For example, oil company Rockhopper is not just only claiming, for example, 50 million from Italy under the Energy Charter Treaty for what it spent on exploring an oil field in Adriatic Sea, but an additional 300 million for profits that the field could have made had Italy not banned new oil and gas projects off its coast. So similarly, a regulatory chill that we talked about may prevent states from enacting a more aggressive legislation to combat climate change because of a fear of a future disputes. On the other hand, as for incentivizing transition, the investment regime can be used as a tool by the state, in my opinion. For example, in order to meet the 2 degrees Celsius goal that is set out in the Paris Agreement, the International Energy Agency estimated that cumulative investments in renewable power would have to total 6 trillion by 2040. So that goal will not be attained if current investment levels do not increase. Another thing to consider when it comes to incentivizing transition, I think investment treaties provide a level of stability that, again, incentivize concerned investors who would otherwise would not go to certain foreign economies. So, and the ISDS system overall provide assurances that investor will not be tied up in legislation and local courts. So those are the things that come to mind, as an initial matter. But I'm happy to hear from my colleagues in case they want to add some other points.
Just one follow-up, and the many panelists can address either part of the question. But I mean, specifically, what should we make of the various renewable cases? And well, we focused quite a bit on renewable cases in Spain. If you think that a transition to renewables is important, is this a good thing, a bad thing, something else? With that, Guillermo, would you like to comment?
So I think one of the lessons that we got out of the Spanish, Italy, Czech Republic saga is that at least now tribunals are starting to figure out what a reasonable return is supposed to be in these kind of projects, right? So I think that's a big concept that it's evolving. And now in the face of the new challenges for climate change and the constraints that states are going through, I think it will depend on first, if the investment panel is willing to be a little bit more lenient when it comes to the reasonable return, right? Investors now are aware that all these things are happening, there are new changes going on. So whether the arbitrators are going to take, they're going to try to calculate the damages awarded to the company as if nothing had happened or vis-a-vis the new regulations. So what a reasonable return looks like, it's going to change depending on how the market is moving forward. So I think that's one of the concepts. The other element that also the investment, that some of the Spanish saga cases bring into the equation is whether now arbitrators, when they are trying to figure out how much they have to compensate or whether they need to compensate, whether they're going to take more consideration to the public interest rationale behind the decision, right? If the decision is just made to take away the investment or take away the value of the investment for the benefit of the state, is one thing compared to taking away the value of the investment because you're trying to address a climate change challenge or a pledge to an international agreement. I think those two equations are different. But before, I mean, if you analyze the previous cases, the early 2000s hydrocarbon cases, we weren't even having that conversation, right? It was all about the rates of return and calculating how much the price of oil was going to be in the next 10 to 15 years, or whether there's going to be a value. Now, in a more meta question, I think it also would all depend on the market. I think I see greatest challenges of states that are still petro-dependent on their finances, the production of oil. There's those going to have a higher difficulty transitioning into any model, right? Especially, and this is one of the unintended consequences of the movement in favor of divesting the investments on international oil private companies, is that they are going to be opening markets for the national oil companies. So as we, ExxonMobil and ConocoPhillips and all these companies start to divest and start doing less investments abroad, we still are in an economy that depends highly on the production of oil. Even if we start reducing our consumption of gasoline for moving cars, we still, after COVID-19, is something that we learned is that petrochemicals are still a big part of the market, right? You can't think about addressing all the challenges that the pharmaceutical industry had to go through, from creating masks and plastics for intubation and et cetera. All those rely on crude production, right? So there is a big still market for petrochemicals. And if ExxonMobil and those companies phase out, you're only opening a market for state-owned companies, and there's going to be more budget being sent, more money being sent into the states' arcs, and more dependency on that. So those states are going to have a harder time, especially again if the divest movement has more traction.
Thank you, Tim.
Yeah, I would just add one thing, since we've talked a lot about the interaction between investment and trade here, is that, when you think about the disputes, for reasons that I think we've all already touched on, the investment dispute sort of landscape looks much more even as compared to the trade landscape. You're seeing, because you're seeing the renewables cases in investment, as well as the sort of traditional fossil fuel type cases, you're seeing basically the possibility of a much more even-handed enforcement. I think, if you're an investment arbitrator, I think you might agree or disagree on kind of on the margins about this claim I'm about to make, but I think you could, with a straight face, say, we are applying principles in a somewhat even-handed fashion. If you go look at the trade cases are entirely about limiting renewable subsidies. You really see a pretty significant absence of any action on fossil fuels, particularly at the WTO. It's just basically been missing in action. So, I think there's a case to be made, at least by comparison, that the investment law system is doing more, again, with an emphasis on disputes, to promote the transition as compared to the trading system.
Great, thank you so much. I think I'm going to pass to a couple questions from the audience, and I think they're related questions. So I'm going to read them all at the same time. So the first is, what are the possible methods of promoting green investments in states that have abolished their BITs? The second, following up on that, is how can EU member states attract foreign investment and better promote green investment when the EU Commission is monopolizing green finance and investment through the prohibition of intra-EU BITs? Doesn't this severely curtail the EU's global competitiveness by sending out the wrong signal to foreign investors? And I turn those challenging questions over to the panelists to delve into the what's going on in Europe with the change of the investment system.
So I'll give a crack to the first question. So abolishing BITs and attracting green investments, I think that's, if something we've learned about the investment regime is that investment treaties are just one more element that is out there for investors to make the decision to go abroad. I mean, we're lawyers and we tend to overemphasize, the contracts and the treaties, and we get obsessed about this. But when you talk to the investors, it's just one of the other elements. They're more interested in the economics of the project and whether there's going to be a market in the long run. So I think renewable energy as a market, it's going to expand regardless of whatever happens with the VITs. Because again, there are good reasons for the renewables to have they're cheaper now. They're producing electricity in a cheaper way compared to other fossil fuels. They have more spaces to grow in the long run. They actually help with the energy nationalism because you depend less on foreign sources. So for states, that's why you see China, for example, expanding enormously their solar capacity and wind capacity, because they don't want to depend on oil from abroad. They want to learn from the mistakes of Western nations when it comes to dependency of oil from abroad. So there is going to be a market, and as long as there is a market, there's going to be investors willing to go and take the risk. I think there are some states that, as long as you have a decent judicial system that can attend some of the complaints that might arise, you're still going to be able to attract. And again, remember, giving jurisdiction, if investment cases are an important factor, you can still have investment arbitration without a VIT, because foreign investment laws can actually give jurisdiction to the tribunals if they are set up in place in that particular jurisdiction, or even in the contracts, you can provide jurisdiction to the tribunals through the contract signed with the state. So you don't actually need the VITs, particularly if that's what investors are looking for. And they are very savvy in trying to put in arbitration clauses in the contracts and concessions as a condition for investment.
Kathleen.
Maybe a couple words to agree with everything Guillermo said. But I don't think we've talked in this conversation yet about World Bank and IMF, which of course takes us to another level. But I do think that without rethinking the financing schemes that you see from World Bank and IMF, that is also, especially in emerging markets, if we're going to be serious about brownfield finance, that it has to involve those institutions and some of the other development banks that are there to support those sorts of initiatives and shifting their algorithms and models to appropriately accommodate the risks that come along with these sorts of investments. Thank you.
So I'm going to just pause now for to read off the CLE code. I'm going to put this up on the screen. I thought I was going to put this up on the screen. Computer is not cooperating right now. Here it is. Okay. So hopefully everyone should be able to see the code. The code is 927345. And without this code, you will not be able to get CLE credit for this panel, and it will not be available after the panel ends. Okay, with that interruption, I'm going to now return to the questions, but just one last time, that's 927345. Okay, our next question, I want to focus a little bit on the USMCA in particular. It was one of the instruments that we've discussed at a few points during the course of our conversation today. And I want to ask whether the investment chapter of the USMCA, with its fairly weak enforcement provisions, is a good model for energy investment governance, and if it's not, where should we modify it, or should we really just throw it in the trash altogether if we were to be able to remake the system however we preferred? And I believe Guillermo has offered to address that question, so I'll turn it over to him.
So I'll give you at least my view. I think that USMCA is not really a good model. I think it's both Chapter 8 and the way the annex were created. The way I call it, they are the Mexican ISDS mechanism. So they were really thought as a way to try to control the incoming administration from changing the rules of the game of the energy reform of 2013. So I would say the annex, the Chapter 14 annex and the Chapter 8, they have a name and a surname, and it's Andrés Manuel López Obrador, right? And so the previous administration, they really want to make sure that there was a protection there. But at the same time, they want to give him something. And so they gave him the Chapter 8 that, as I already said, I think is more of a placebo kind of chapter than an actual chapter. So I wouldn't use the USMCA as a model in and of itself. And I think it's going to be interesting to see how it plays out now that the Mexican energy counter reform has been presented. One of the interesting aspects, and this goes, I think Kathleen can tell us more about it. One of the interesting aspects of the energy reform is that it's being framed under a national security threat. So the actual constitutional amendment, it states that for the sake of national security, Mexico has to achieve self-sufficiency and a constant flow of energy to consumers. So ultimately, they're going to be framing it under the, I think, if I was the Mexican government, there are many reasons why probably the cases are going to be hard to win. But one of the arguments that are going to be placed in place is that the existing energy reform, the previous energy reform, puts in danger the essential securities of the state, because then the state has to have more control, and that's why it's needed. How those exceptions are going to play out, Kathleen has much more experience than me in analyzing exceptions for national security in trade agreements. But I think it's interesting to see that they're going to start to framing it in those terms. And again, that goes back to my initial introduction of energy nationalism. Interesting enough, when the Biden administration also canceled the Keystone XL pipeline, all of it was also framed under the national security threat of climate change, right? They wanted to send a message abroad that the United States was going to be serious about its climate commitments because it's on the national security interest of the United States. So again, national security is going to be thrown out for both ways, right? We want to control more the grid, and at the same time, it's for the climate change purposes. So, but I don't know if Kathleen wants to add something to this.
Maybe just a brief word with David's permission.
Please.
And I'll maybe take us in a slightly different direction than what Guillermo said, and just in the sense of not whether this should be a model, but whether this is the model going forward. I think that's a question that a number of us are asking. That is, was USMCA the unicorn, right? Is there USMCA exceptionalism that we should be thinking about? It was the first FTA in a decade. We don't know exactly, they don't come along every day, and it looks like we won't be having any more here for a while either. So I think on the one hand, has it set a new floor in some areas? I think that's probably true. But given how difficult change is in our political apparatus, I think a lot of what the future holds depends on the politics of that particular moment, who's in what branch of government, and particularly it can be individual specific, or there are personalities that drive this conversation now more than say a decade ago. And then likewise, who is the partner, or who are the partners on the other side? And I think those will be particularly important going forward as to whether they trigger all the things that Guillermo said, whether the salience of national security in the conversation or other policy choices that come alongside the ISDS conversation. I think that all remains to be seen.
And if I may add something to Kathleen's point, one of the interesting things, the aspects from the USMCA, I think it has more mechanisms, and going back to her original remarks, for state-to-state cooperation, right? So we see a lot of panels and dialogue, high-level dialogues, opportunities to try to resolve some of the disputes in the environmental chapter, labor. And so it would be interesting to see how they played out in the energy sector as well, whether the Mexican government might be more willing to engage with the Biden administration to have these talks on a bilateral way on panels, rather than give the signal to the investors that we're going to get out of this. If you want to bring a claim, that's your decision, but you're not going to get the support of the U.S. government. So that's again, we're reversing now some of the original intentions of the investment regime. It was depoliticize the system, and now we see more cooperation. This in the U.S., Mexico, USMCA side, there's been a lot of dialogue happening.
Anyone want to hazard a guess whether that will be a successful way of managing the various disputes and other tensions that arise? Okay, that was a bridge too far. I will move on to the next question. So at the most general level, are there alternative models of energy governance that would facilitate the transition to renewables better than the contemporary version of a traditional investment treaty that maybe we see in the USMCA, although as we've been discussing, it's got quite a few variations on tradition, especially when it comes to dispute resolution, but also its context in the broader agreement.
I could start on this, David, and look forward to hearing what others have to say. I mean, I think, yeah, as you mentioned, we've sort of been touching on this in different ways in each of our remarks. I think, as I said earlier, we probably do need to think outside the box on alternative models. And you know, my pitch is that should happen perhaps at the areas where trade and investment models could intersect. But, you know, we tend to be in this responsive posture in all of our agreements across both subfields. We were writing these commitments to deal with bad state action. But again, I think as this conversation is illustrated, for these alternative models to work, we have to be thinking about opportunities. And the earlier questions from the audience, I think, led us down this road. The investment issues are changing, and with that, the broader umbrella of investment law. So I was at another meeting recently where a colleague said to me, if we keep pushing climate change reform without addressing demand, some of these initiatives will just be overly costly and unrealistic for investors. Right? So we have to create these conditions for more private capital, I think, to come into the area. And I mentioned earlier emerging markets, which I think are going in the wrong direction. I'm not sure it's clear among investors in this sort of race to make these investments in to reduce carbon emissions, whether this is a burden or whether this is an opportunity. And on the one hand, you hear people say the time is now, you know, strike while it's hot, let's get these new technologies going. But on the other, it's extremely costly, right, for many of them to make these moves, and not just in dollar terms. So I think throughout, as we sort of look at the landscape, our traditional concepts of investment law are perhaps underperforming and necessarily need to respond, or ideally get ahead of some of those changes that will be necessary.
Does anyone else want to add anything on that question? Guillermo, please go ahead.
Unless Tim, did the team raise? No.
Oh, sorry, excuse me. Tim, please.
So I was just going to say very briefly, you know, there's a major opportunity to leapfrog fossil fuel technology in the developing world, where I think there actually is. You know, the question was about the model, and I think Kathleen is right. I agree with everything Kathleen said. I think we could tweak the model if we really open up the box, right? We could imagine tweaking the model to favor renewables over fossil fuels. But the big driver, I think, is what can the investment law regime do to support the diffusion of investment and renewable technologies to the developing world. We talk a lot about, you know, the United States, the EU. The long-term game is not in the US and the EU, right? The long-term game is in Africa and Asia and in South America. And so, you know, I think that's the place where, you know, if I was thinking about focusing my efforts, that really would be where I would go.
Just very quickly to add to Tim's and Caitlin's points. I think one of the challenges is that the investment regime was, at least one of the reasons why it was created was to provide stability. And we're facing right now is a system that requires helping to transition to different modes. So it immediately contradicts the whole concept of giving stability, right? You have to be able to adapt to changes and transition to different models of, you know, your energy matrix that you want to create. So again, the system was created again to provide stability for oil and gas companies. But right now, what we need is to help them transition to a different model. And so how do you create an international economic treaty that deals with all these issues? And it's not only about protecting investments in one place, also transit states, right? Again, building all these pipelines that are going to transit, and you're just going to transport one resource to the other. Those are interesting conversations, and I think need to be addressed separately than, you know, big trade questions and big and general investment questions. If I was ideally, I would carve them out from most of the investment agreements and carve them out from the trade agreements and have a specifically energy-related principles, both to trade and investment.
So in effect, some variation on the Energy Charter Treaty, although potentially with completely different principles. I just want to follow up on a question, or I sort of posed before, about the Spanish renewables, and just, I mean, one way of looking at them is those cases actually may have enforced, well, they may have forced Spain to maintain its commitment to certain incentives for the transition. But at the same time, as I think, you know, Diora also pointed out, there have been cases that go the opposite way, where you've got the traditional hydrocarbon energy producers using the investment treaty regime to maintain and prevent changes to the regulatory scheme to reduce carbon. And I'm just wondering whether there's a way to have at least in the investment sector of the puzzle. Of course, climate change is quite multidimensional, trade, carbon border adjustments and all of that, but to turn it into more of a one-way ratchet where perhaps the investment treaties would not restrict states that want to move away from hydrocarbon-based energy, but at the same time would maintain their commitments to new sorts of renewable energies. I'm not sure whether there's any existing mechanisms that would work in that way, but just as a closing thought, I'm wondering whether perhaps if some of the non-precluded measures provisions of investment treaties that specifically reference environment might actually help create that sort of one-way ratchet. Tim?
Yeah, so I think there's potential in these kinds of provisions, but we're not there yet. The Echo Oro decision that just came down, which was not a non-precluded measures provision, it was a GATT-style general exceptions provision, but it just suggests that there's a long way to go in investment law to really sort of think about how we're going to apply these exceptions in the way that was intended. And you know, in Echo Oro, right, Colombia was the respondent, and of course it wanted to claim the exception, but then Canada comes in and says, yes, it's, you know, there's that, you know, makes a submission, yes, there's no obligation for compensation here, and so you're really stuck in a situation in which the arbitrators seem to be resistant to the idea of applying what are, you know, kind of maybe a little bit too loosely written provisions, and the USMCA non-precluded measure provision, I think, is actually even more loosely written than the kind of GATT-style general exceptions provision. So I think there's some drafting work to be done in new agreements, but there's also some work to be done I think, you know, for lawyers and practitioners who are making arguments to really think about how to apply these exceptions in ways that give effect to you know, what governments are trying to do and the imperatives of facilitating an energy transition.
Thank you. I believe we've reached the end of our time. I want to thank all of the panelists once again for their excellent comments. It's been a really enlightening session. I also want to thank all the attendees for listening and for your questions, and finally to ABILA for allowing us to participate in this event. Thank you, and have a good afternoon.